For this final section on civil liberties and the Bill of Rights, let's talk about the right of privacy. I just want to set it up here, and then in subsequent slides we'll walk through some of the details. So the idea here is that the court is going to creatively interpret the Bill of Rights to include a right to privacy. Does the Bill of Rights mention privacy? It does not. And yet the court ultimately deduces that if you take all of these amendments, 1 through 9, put them together, get a little creative, stir them just right, you get this thing called the right of privacy. So it's been controversial because it does involve an interpretive leap of faith, if you will, that's a little unusual, right? Normally the court will anchor their claims to very specific language in the Constitution. In this area, they really depart from that to some extent. I think it's defensible, and yet I recognize that it's also deeply controversial. And when the court creates this right of privacy by sort of creatively reading that Bill of Rights, they do talk about the Ninth Amendment. It's one of the very few cases where the court even mentions the Ninth Amendment, right? And remember what that Ninth Amendment is. It says that despite the fact that we've listed a bunch of rights and liberties in the first 8 amendments, that does not mean that there are not others that we the people possess. Right, so that was to satisfy the concern of some that if you start to list specific rights, then the government will only respect those rights, and anything else will not get respected at all. So this was basically a way to create a defense against that approach to the Bill of Rights. So in that sense, it's entirely legitimate, right? But it is ultimately kind of a natural law claim, right? Very similar to Jefferson's declaration that we are endowed by our Creator with certain unalienable rights. And then it's ultimately left up to the courts. And in a case where you talk about the Ninth Amendment, it's left up to the courts to decide what those unalienable rights are. So it gives the court a lot of degrees of freedom. That's normally why they don't use it. Normally because it puts them out there on a limb a little bit. Normally they're sticking to, let's say, free speech in the First Amendment, or the free exercise clause of very specific things that they anchor their decisions to. But once you use that Ninth Amendment, right, it's kind of a blank check that we the people possess additional rights and liberties beyond those listed. Well, what are they? Whatever the court says they are. So that's part of why it becomes controversial. All right, with that being said, let's explore this in a little more detail in the case of both abortion rights, where it's first invoked and deeply controversial, and then some of these questions involving sexual orientation. All right, so the Supreme Court, in a remarkable and remarkably controversial decision in 1973, held for the first time that the Bill of Rights contains a right of privacy, broadly understood, and it applies to a woman's access to abortion. Before that, of course, right, the court had developed that idea of a right of privacy, captured in the Bill of Rights, broadly understood, in a case called Griswold v. Connecticut. This was a right of privacy established in a pretty uncontroversial situation involving the right of a married couple to receive medical advice and devices from their doctor for contraception. The court struck down that Connecticut law, driven by Connecticut's history of a strong Catholic presence in that state, as a violative of this right to privacy. Right, and then that becomes much more controversial when it's applied to abortion in 1973 in Roe v. Wade. Now, the court did note in Roe v. Wade, there's boundaries on this right, just like there are for all rights in the Constitution, in the Bill of Rights. The state can intervene at the end of the second trimester in order to look out for the life of the fetus. Once the fetus reaches that third trimester of a pregnancy, the state has the right to step in and protect that fetus if they so choose. Although the court also said, hey, there needs to be a life or health of the mother exception to that. That if there's some sort of a complication, a serious complication late in a woman's pregnancy, the state cannot forbid that late-term abortion. Okay, that's Roe v. Wade. This was modified In 1992, as the court became more conservative because of a string of Republican, a string of Republican presidents like Reagan and H.W. Bush, and what the court ruled in Casey, 5-4. I think Roe v. Wade was actually, was that 7-2? That was a strong decision in terms of the vote. Casey is 5-4. Sandra Day O'Connor, Justice Sandra Day O'Connor writes the majority in Casey. She was a Reagan Republican who many thought would vote to overturn Roe. She didn't. That was a shock to the pro-life movement. And instead, she ruled that, well, 2 modifications to Roe. One, the trimester framework is too rigid. States can step in to preserve the life of the fetus from fetal viability forward. Right, and fetal viability comes before the 3rd trimester. Not much before, but a little before. And that's moved a little bit over the years because of evolving medical technologies. So, right, in Casey, the court permits the state to intervene a bit earlier, although they still have to preserve the life or health of the mother as an exception after fetal viability. In exceptional circumstances, if an emergency abortion is needed, states need to allow it. Okay, that's Casey. That's part 1. Part 2 is, and more significantly, I think, the court rules that states can enact all sorts of regulations on access to abortion from conception to fetal viability, as long as those regulations don't impose an undue burden on a woman's fundamental right to choose. Right, so examples of that today would be states that say before a woman gets an abortion, the state has to provide counseling. And right, that's going to be counseling designed to persuade the woman not to have the abortion. And then once the woman receives that counseling, she has to wait either 24 or 48 hours before she then makes a decision regarding her abortion. And the court has said that's fine. And under Roe, that was not permissible. Under Casey, it is. The court says, those are low-key regulations. They don't impose an undue burden on a woman's fundamental right to choose. And that was the big modification of Roe in Casey. This was kind of, I think, a compromise decision. That was, I thought, a decent compromise. It didn't really make the pro-choice or the pro-life forces very happy. And that becomes kind of the uncomfortable compromise for many years. Really, right up to 2022, where the court, right, reshaped by former President Donald Trump, president at the time, Donald Trump. Ruth Bader Ginsburg dies just before his term is over. He quickly replaces her with Amy Coney Barrett, and that swings the court to a supermajority of conservatives, 6-3. 6 conservative Republicans, 3 liberal Democrats. Right now, the court has the votes to do what they want, and they do what they want in Dobbs. 5 of the justices, that would have been what? See if I can remember all of them. That would have been Clarence Thomas, Gorsuch, Kavanaugh, Amy Coney Barrett, and Samuel Alito. They hold that now is the time to overturn Roe and Casey. Those were wrongly decided, and it's up to the states 100%. States can ban abortion from conception forward. They can permit all abortions right up to fetal viability or beyond. Up to the states. It's a states' rights decision. It's provoked quite a backlash, and we'll see where that all ends up, but there's been quite a backlash. Chief Justice John Roberts, interestingly enough, right, also a Republican. He does join his 5 conservative brethren on the case before the court, a Mississippi law that essentially banned pregnancies after 15 weeks. He said, I agree with that. Let's uphold that law. But let's make that the new standard. Let's say, hey, women across the country are guaranteed access to abortion up to 15 weeks of their pregnancy. After that, the states can step in. But he does not win over any of his conservative brethren on that larger argument. So that's why I say 5-4 on overturning Roe. 6-3 in the instant case. 5-4 on the larger issue of the status of Roe and Casey. And here we are. All right, thanks all. The second area where the court has invoked privacy rights, again in a controversial way, although it's increasingly not that controversial, gay rights. And it ends up that when we get to same-sex marriage, that's going to be more of a 14th Amendment equal protection issue. So here we're going to focus more on laws that states have promulgated that target sodomy, anti-sodomy statutes, typically directed at same-sex couples and sexual relations in the privacy of their own bedrooms, consenting adults. The court upholds just such a law in the state of Georgia in 1986 in the case of Bowers v. Hardwick. The court looks at it in just this way. They ask, okay, you've got an anti-sodomy statute. It was applied against a same-sex couple caught en flagrante in the privacy of their own bedroom, consenting adults. The question for the court was, does the Bill of Rights protect gay sex in a sense? Does it vindicate the right to engage in same-sex sexual relations? Did the founding fathers intend that result? And the court says, look at from that point of view, heck no, there's no right to gay sex in the Bill of Rights. That's ridiculous. We hold that indeed, if Georgia wants to have such a law, they can have such a law. What happened between 1986 and 2003? Big changes in public opinion, changes in the politics of gay and lesbian, bisexual, transgendered, and queer civil rights. You got a movement underway helping to move public opinion. The politics of Congress are shifting on this issue. The politics of the states are shifting on this issue. The courts are shifting on this issue. And so the same issue really fundamentally comes before the court again in 2003, and the court goes in exactly the opposite direction. They overturn Bowers v. Hardwick, say that indeed the question is not, is there a right to gay sex, but does the government have the right to interfere in the private lives of consenting adults having sexual relations in the privacy of their own bedroom? Looked at in that way, the court says, heck no, the government has no such authority, no such power, that violates the fundamental privacy rights of all Americans. So the court reverses course on this issue between 1986 and 2003. Interestingly enough, in the Lawrence case, Sandra Day O'Connor was in the majority. She was also in the majority in Bowers v. Hardwick. So she obviously changed her mind. Some of it also were changes in the court's composition. Scalia, very unhappy with this decision, as you might imagine. He's an original intentist, deeply conservative. He had an absolute fit in Lawrence v. Texas. And in fact, in his dissenting opinion, he opined that, hey, look, we're decriminalizing gay sex. What next? Incest? Polygamy? Bestiality? So he thought that this was the road to Gomorrah for sure, that we were sliding down a slippery slope straight to hell. And he also said, look, if we're going to do this, eventually we're going to validate same-sex marriage. The court majority said, no, we're not dealing with that issue. We're only dealing with this issue. But Scalia correctly anticipates that if the court is going to vindicate this right in Lawrence v. Texas, they're likely to go that next step and vindicate the right to same-sex marriage. And it appears that the court is on the very cusp of doing just that. Sometime here before July 1 rolls around, we're likely to get that decision from the court. All right. So that one over time I do think has become less controversial. I think that war is largely over, especially on anti-sodomy statutes. That war is definitely over. And you connect this with same-sex marriage, which I think you can, although again, same-sex marriage is more of a 14th Amendment equal protection issue. But if you connect it conceptually, as Scalia does, I think correctly, you can see, right, that issue has also gone in a certain direction where it's not all that controversial. Not all that controversial anymore. So those are the two areas where the court has invoked a right of privacy: abortion rights and one dimension of gay rights. The one still deeply controversial, the other one increasingly less controversial.